Hey, what's up, guys? So the UCC did about a 2 hour Twitter Spaces yesterday, and this was probably the best Twitter Space that they have ever done. So what they covered was a lot, and I went through it, and I included a lot of timestamps for you guys. So they talked about why they picked Fahrenheit as the plan, what it means for voting, orderly wind down versus the NewCo, and then they had a really, really long discussion about taxes, which I think is very, very interesting, especially how this will affect your taxes for next year. They also talked about crypto distributions. They went over PayPal and why it is going through PayPal. They talked about what happens if people don't get their crypto off. Where will that go? They talked about CEL token, voting, a little bit about custody claims. Then they talk more about the details of the voting for the convenience class, for loans. They go over XRP and Flare. And then there's about 30 minutes of a really good FAQ talking about clawbacks, talking about distributions, again, why they're going with PayPal, and all sorts of different things like that. So Aaron Kolodny was the lawyer that did this Twitter Spaces. He represents the UCC over at White & Case, and he said over the next probably couple days, he will be releasing a video going over how to vote. So there's a reason I have not made a video like that yet. The UCC's lawyer is literally going to be going over this, so I'd much rather have him go through it on his end so I don't spread, false information or make a mistake that could ultimately cause damages for people. So I'm waiting for him to come out with his video and a couple more things over the next week or two before I will make probably my own video about how to vote and what that looks like. So now let's get to the Twitter Spaces. Feel free to go to the timestamps if you just want to jump to specific topics because this is quite a long Twitter Spaces, but again, it is very, very good.
So again, this is Aaron Kolodny from White & Case, counsel to the UCC. I've got Scott Duffy, one of our co-chairs, up on the stage, and Ken Erler, who's a financial advisor from M3 to the committee as well. I'm also anticipating that Anthony Sexton from Kirkland & Ellis, who's one of their tax partners who specializes in restructuring, will join us for a little question and answers to answer some of the questions people had about the tax treatment in the plan. We're going to spend about an hour and a half today. And as we posted on our Twitter, we got a lot of questions through our email, and which were really helpful and helped us kind of prepare, direct, and make sure that we were able to answer the things that most people had questions about. We'll open it up for live questions at the end, but I want to make sure that we get through everything first. And if we're not able to have a significant time for live questions, we'll have another one of these soon. So I don't want everyone to think that we are somehow dodging live questions, but we're just trying to be efficient with our time because, as you all know, we're trying to work hard to get this Celsius out of bankruptcy and coins back in all of your pockets. So I have, I think, maybe 4 or 5 different agenda items that we're going to go through today. The first, I want to reintroduce our committee members and give a bit of background on each. We had a meeting with the EARN group after the mediation in which we did this, and I think they found it pretty helpful. So I think I'm hopeful that will give everyone a lot of context about who has been really spending a lot of time on this case. I'm then going to go over the voting packet, and we are going to be publishing a video on voting soon to help you all walk through the ballots. I am the person narrating it, and so it might be a little dry, and but I'm hopeful that will help everybody get through. I'm then going to talk about the confirmation timeline, and then I'm going to toss it to Scott, who's going to talk about NewCo, and then Ken's going to talk about the wind down scenario. And following that, we're going to move to questions. So at the top, I want to talk a little bit about our committee members. These are all people that were appointed by the United States trustee and have volunteered, thousands of hours working on the Celsius case, trying to get the best recovery for all of you. I know that you have seen them, heard them, some of them. They never signed up to be the public faces of this. And I can say that Scott and Tom have put themselves out there And a lot of our other committee members, are eager. Well, I will say that they've been intimately involved with the entire process. I've seen some Twitter messages out there saying that there are committee members that don't participate, that are never there. That's absolutely not true. Every single one of our committee members has been involved in this process as we've gone on. So to start from the top, Tom DiFiore is one of the two committee co-chairs. Tom first got into crypto in 2010, and he's owned and operated a Bitcoin mining company from 2010 to 2015. He also owns and operates an auto group with more than 150 employees, as well as a reinsurance company. In Tom's spare time, he enjoys watching the Yankees AA affiliate, the Somerset Patriots, where he also sits on the advisory council. Scott, who's joining me today, is the other co-chair of the Unsecured Creditors Committee. He's the CEO of ICB Solutions, Inc., which is a company focused on digital assets, decentralized finance, and blockchain technologies. Like Tom, Scott was an early adopter of digital finance, mining his first Bitcoin in 2011, and seizing opportunities such as the Ethereum crowd sale in 2014. He's spoken about cryptocurrency at the Ohio State Bar Association, Nationwide Mutual Insurance Company conferences, and an association of governmental accountants. Before Scott moved into the blockchain sector full time, he worked at the Department of Defense, where he played a key role in updating legacy payments and accounting systems across all armed services and multiple defense agencies. Keith Noyes is another one of our committee members. He has over 30 years of experience in financial markets. His first blockchain investment was in 2011 into a company called GuardTime, which is an Estonian and Swiss company. Since then, Keith spent 12 years at the Asia Pacific Regional Director of the ISTA, International Swaps and Derivatives Association, where he had extensive experience interfacing with regulators. From 2020 to 2022, he was the Chief Risk and Compliance Officer of a Swiss crypto brokerage firm. He also sits on the board in the Risk Management Committee of OTC Clearing Hong Kong, which is a subsidiary of the Hong Kong Exchanges and Clearing. Christopher Coco is another one of our committee members. He works in food service management, and he purchased his first Bitcoin in 2013 and ETH in 2017, and has been holding ever since those purchases. He became involved in Celsius beginning in June of 2021 and made his last deposit in May 22, all into the EARN program. Mark Robinson, another one of our committee members, has spent the past 14 years practicing law as a judge advocate in the Army. Mark's practice mainly focuses on criminal law, where he's prosecuted and defended many individuals. He also has experience in administrative law and contract litigation. Mark bought his first crypto in 2021 after speaking to a close friend about Bitcoin. And since then, he spent hundreds of hours educating himself on cryptocurrency. Mark has told me that he's now thoroughly orange-pilled, and he primarily focuses on Bitcoin. Mark first invested with Celsius for many of the reasons all of you did, because he believed that this provided safe yield. He believed in the promises that Celsius's pre-petition management told the public, and he has been very passionate about maximizing the return for creditors here, and he relates to many of the creditors who suffered significant harm. Another one of our committee members, Carolyn Warren, is a marketing professional who has managed hundreds of millions of sales over more than a 2-decade career. And Carolyn runs her own Bitcoins miners and started running those in 2021. Andrew Yoon, our final committee member, first purchased crypto in 2010 and has a strong belief in the power of decentralized networks and technology. He strongly believes that Bitcoin is a potential solution for the current state of global finance and categorizes himself as a Bitcoin maxi. Andrew's got over a decade of experience as a serial entrepreneur, launching multiple startups across various industries, including equipment design, engineering services, dry ice manufacturing, chemicals and material processing, and import and export businesses. He manages over 50 plus employees over 50 states, And he believes that that gives him a deep understanding with startup companies and the importance of people management, cash flows, and markets. Now, you all should have received or will receive shortly your voting packet from Celsius. And as I mentioned, we'll be posting a video shortly that walks through, does a video walkthrough of that ballot. I will say it's my first attempt to film one of these videos, and for all of those out there that are do this more regularly, I have a deep appreciation now for how hard it is both to do and to listen to yourself afterwards. I don't think I can emphasize enough how important it is to vote. Voting is your chance to have your voice heard and your input heard in these Chapter 11 processes. If you've got any questions relating to voting, you can shoot an email to our email address, which is the same one that we used in our Twitter to field questions for this town hall. That's Celsius Committee Inquiries at whitecase.com, or to Stretto, who is probably the better party since they're the solicitation agent. And their email address is celsiusinquiries@stretto.com. I want to remind everybody that the deadline to submit your ballots is September 22nd, 2023 at 4 p.m. And you don't need to submit your ballots now. You can wait. We're going to have a number of these calls. I know Fahrenheit's got a number of different spaces, but everybody needs to make sure that if you want your vote counted to accept or reject the plan, it needs to be submitted by September 22nd, 2023. So to get to the third point before I toss it to Scott, I want to talk a bit about what's to come in the case. So I think yesterday or the day before, the debtors filed a schedule for confirmation, which can be found at docket number 3356 on the Stretto website. This is the court-approved schedule for confirmation. Some important dates that I want to highlight as we go down. On September 6th, the debtor and the committee are going to file legal briefs on the CEL token legal issues. September 8th is the deadline for filing the plan supplement. The plan supplement, we filed a couple versions already, which include ADR procedures, which were the subject of the last court hearing, and we are currently negotiating or intend to negotiate with the parties that appeared at that hearing. It will also include corporate documents with respect to NewCo, including a management agreement and an agreement with US Bitcoin and other governance documents, and the identities of the board members for NewCo. The plan supplement is a living document, and it may be updated prior to the confirmation hearing as documents are finalized. On September 20th, we're going to have responses to the CEL token legal briefs. September 22nd, as we discussed before, is the voting deadline. And after all votes are counted and tabulated by Stretto, they'll publish on September 25th a report of the votes on the plan. September 28th is the hearing for the CEL token legal issues, to the extent that the majority of CEL token holders have not voted to accept the plan, or the debtors have not otherwise reached an agreement with the group of ad hoc CEL token holders. And then October 2nd is the start of the confirmation hearing. We've broken the confirmation hearing. We have 3 weeks reserved with the court. We've broken it up, or tried to break it up on the schedule into topics. We anticipate that the first week of the confirmation hearing is going to concern whether the plan meets the requirements of the Bankruptcy Code. The second week of October, the court's in recess, and we come back in the third week of October, which will be a continuation of confirmation requirements to the extent necessary, and a CEL token valuation hearing to the extent necessary. The fourth week of October is going to be a trial on equitable subordination of the claims of Mr. Mashinsky and certain other members of the debtor's pre-petition management. Now, I know that everyone's first question is, when am I going to get my distribution? When is the effective date going to occur? And so after the confirmation trial, we expect that the court may need some time to deliberate and potentially write an opinion before it makes a decision with respect to confirmation. So it's a bit uncertain when the confirmation order will be entered. But once the confirmation order is entered, then there are a number of conditions precedent set forth in the plan that need to be met before the plan can go effective and distributions can be made. I think this is a long way of saying that there's no date certain for when the effective date will occur, and there's a number of different variables which could affect when that happens. That said, in my mind, the soonest that the effective date may occur is likely in November. And as we've said kind of over and over again, we are working our hardest to make sure that we emerge before the end of the year. But all of that is subject to a number of uncertainties. And as we've seen with this case, you can never predict what's going to happen the next week. Now, I want to flip it over to Scott to talk a little bit about NewCo and our experience and process of selecting Fahrenheit and the NewCo plan.
Hello, everyone. Thank you all for making time and attending. As many of you know, in May, we had an auction for the plan sponsorship, and we were able to improve the reorganization deal significantly, and we selected Fahrenheit as the plan sponsor. Just to give you some color on that, why did we select Fahrenheit? Because they're a credible group of proven operators first and foremost. Many of us spent a lot of time in New York with these principals. We got to know them. We checked the references, asked their current hosting and building customers, their counterparties. I personally have been to see US Bitcoin's sites in Texas. I saw their Delta site. They stood up in 40 days. I saw the trailer that some of these employees lived in, working both day and night shifts. I saw their operations and asked them more questions than they could count. Celsius has diligenced the Fahrenheit staking technology, and we believe that Fahrenheit team has demonstrated that they're all good operators and very trustworthy set of hands. It was a very tough decision for us. All of the committee members met just about daily and participated in the auction that lasted for almost a month. And in the end, we voted unanimously to select Fahrenheit as the winner. And I think that speaks pretty powerfully as to our conviction in the decision. The reason we did so, I think, primarily, in my opinion, was their mining capabilities. It's going to be the core asset of NewCo, and it's the surest business to move us through confirmation and to the other side of this bankruptcy. When you compare NewCo to other public Bitcoin miners, I think it will be very unique because it will have no leverage and a significant scale. NewCo is not just going to be a miner. It will also have its own Ethereum staking business. The debtors have tested the technology, the staking capabilities, proof group IP that was contributed, and the results show that NewCo will be able to achieve a higher rate of return than individuals like us could achieve staking our own ETH, just given the scale of the position. Having operating proven staking technology scale and a public company platform, the staking business will be poised to capitalize on opportunities as regulations become clearer. Fahrenheit is committed to being disciplined and compliant. Two things that were incredibly important to us after all of our firsthand experience with Celsius. It was not easy to switch bids because we knew that there could be delays, and this case is incredibly painful and expensive for all of us. But to their credit, the Fahrenheit team has dug in. They got to work immediately and made sure that we stayed on track. For those that have heard the video that the Fahrenheit team did on Monday, you may have heard Joel Block, the proposed CFO for NewCo, describe how the day after the auction, he dove into the audit process required to go public. And by all accounts, he has done a fantastic job. It's gone very well. We continue to progress forward. In addition, US Bitcoin has also lent a hand to the mining business, and we've already seen favorable results. And although I can't disclose the results today, I look forward to discussing them with you all as soon as they are made public. I do know that the Fahrenheit team is going to hold a number of events to include a mining learn-in on August 31st. And for those of you with questions, I highly encourage that you attend, as I will. And I really do want to stress the governance in NewCo will be key. There's nothing that we want more than to ensure that we are all delivered into credible, trustworthy set of hands, because this process has been so painful. We've been at this board selection process for months and are nearing a conclusion. Candidates that have public company board experience, audit committee experience, crypto experience, and significant creditor experience in this bankruptcy, and members of the committee, myself included. We're at the final stages of that process and look forward to announcing our selected slate soon. As everybody knows, this has been a very long process and we are all very frustrated. I need you to know that serving on this committee has been my full-time job for over a year now, and it's a job I don't get paid for. But a lot of my personal wealth is tied up in this bankruptcy. The collapse of Celsius was absolutely devastating for me, and I know it has been for you as well. And I'm driven to provide the best outcome, not just for me, but for all creditors. And last, I would like to just say how fortunate it has been for me to have been banded together with 6 other similarly motivated individuals who have generously devoted their time and their expertise. None of these choices have been easy, but we have all worked together collaboratively as a team to get where we are today. We are on the verge of confirming a plan and to be the first crypto company to emerge from Chapter 11 as a new operating company. And with that, I'd like to toss it over to Ken on the orderly wind down.
Thanks, Scott. Hi, everybody. This is my first time addressing you all, so I just want to start with a quick thank you. Thank you for attending and listening, leaning in to try to understand and supporting us through the case. It's a complicated case. I know there are a lot of questions. The math is complicated. There are a number of different financial projections, et cetera. You know, we're here to help. So on that, we know that there's been a lot of discussion and questions we've seen regarding the comparison between the NewCo transaction and the orderly wind down. It's not typical in a bankruptcy to have sort of an orderly wind down built into the plan, and it is complicated. So we wanted to walk through and explain a little bit more on what that means, because it is important to you. So in both scenarios, creditors will receive recovery through liquid crypto and not liquid crypto, right? Through equity or other shares in liquidating trust. For people in the convenience class, and that's the kind of 80% or so, a little over 500,000 creditors with claims 5,000 and below, you'll get the same treatment in either scenario, right? It's a liquid crypto distribution of about 70% recovery to your petition date claim. For the people outside of the convenience class, right, those with claims above $5,000, in the orderly wind down, you will receive a higher level of liquid crypto, right, about $275 million more liquid crypto, but the overall recovery is less, about $244 million less. So lower total recovery, but slightly higher portion or share of that coming from liquid crypto. There are also differences on when and how you'll receive those distributions and recoveries. In the NewCo transaction, we'll have the company itself, right? And the company is going to take on those illiquid assets, the DeFi positions, the VCP investments, the staked assets, et cetera. and creditors will get immediate liquidity of those through their shares that they can trade, hopefully on NASDAQ. In the wind down, those illiquid assets will be put in a liquidating trust. Shares of liquidating trusts historically trade at a significant discount. Through the backup plan, right, and the liquidating trust, those assets will be sold, right, and monetized over time, and the distributions of those sales will be sent to people. But the timeline is uncertain, and it could take several years to actually maximize the value and distribute the value from those assets in the wind down. So just to put it simply, the wind down results in less overall return over a longer period of time. Switching to a wind down at this point may also result in delays in our emergence from bankruptcy. We've worked very hard to try to resolve these cases as quickly as we can, right? And so if we needed to break glass and pivot, we'd have an option to do so quickly. Scott talked about the auction process, and one of the reasons why we secured a backup bidder through that is so we'd have that optionality and ability to do so. But Plan A, the NewCo transaction, is still our priority, right? And where we need to focus effort to make sure we're ready to get out of bankruptcy and emerge as soon as possible. So if we do need to pivot to a wind down, it could cause some additional delays. You've heard in other events and some of the points that Scott just referenced about the progress we've been making on the NewCo transaction and preparing for emergence. For instance, the audit work in preparing for NewCo has been progressing well. We've already made submissions to the SEC about NewCo. There's no guarantee that if we needed to pivot to a wind down, that the auditor would continue in that event, or that the submissions and the filings we've made wouldn't need to be revised. Right? Any of these types of things could lead to time delays or other uncertainty. If we do need to flip to a wind down, the estate needs to evaluate what sort of the best path and option is for the mining business. Again, we have the brick plan, and that's very important for us to be able to have a default path. That's still subject, and we're evaluating bids, and we'll look to see what the best option is if we needed to pivot to a wind down on whether that's a standalone entity or what the best way to maximize value and provide liquidity to folks for equity in that mining business. We're not waiting. All of that work is still running in parallel to the stuff we're doing now on Plan A. However, if we do need to pivot, that process is going to take time, and it's going to introduce a level of execution risk. So if there is a better option where we think we can maximize value, we will pursue it. But right now, our focus is on moving forward with Plan A and the NewCo deal and developing these backup bids. So in the instance that we do need to pivot, we can do so on the best terms with the least delay.
Thanks, Ken. So one point I want to make is the vote on the plan is to vote for the plan as a whole, and that is Plan A. We are proceeding with Plan A, which is the NewCo transaction, which, as Ken and Scott said, we firmly believe is the best transaction here. If you vote no, it's not a vote for the orderly wind down. The reason why the orderly wind down is included in the plan and the disclosure statement is if there are complications that arise, we want to be able to move to the extent we need to without having to go through the solicitation process again. And so if you read the plan, it considers a motion that will be filed to move to that. But, we hope that never occurs. We hope that we all push forward. The NASDAQ listing goes great, and we're all sitting here in November or December looking back at this and saying, we did a great job. This company has been launched. Coins are back in people's pockets, and you are all now in a good set of hands. So to move on to the question and answer phase, we received a significant number of questions to the email box, and I want to thank you all for sending those questions. And a number of people, I think, helped collate a lot of questions from the community. I know Crypto YOLO sent us a number of those, which I think he has gathered from a bunch of different folks, and that sort of help really helps us focus and make sure that we're able to answer the questions that most people have. So yesterday, I reached out to Anthony Sexton from Kirkland, who's a partner in their tax group, who specializes in restructurings and has really been, one of the people that has leaned in and tried to find the best solution for creditors here. And, I want to allow Anthony first to describe the process that he's gone through to put together the disclosure statement, describe the tax disclosures in the disclosure statement. And then I'm going to ask him a couple questions that have been posed by customers about the tax disclosures. So Anthony, with that, I'll toss it over to you.
Thanks, and thanks everyone. I know listening to someone talk tax at 10:30 in the morning isn't everyone's idea of fun. I just want to level set. In 99 out of 100 restructuring cases that I work on, my focus is on the tax consequences to the company, with the tax consequences to the creditors being kind of a afterthought for me. I kind of figure that's someone else's job. The debtor is my client. That is not how we approached this situation at all. I have been working hand in hand with the tax lawyers at White & Case, and just doing everything that we can to kind of develop a body of law from scratch. Because as of all of you that are familiar with this world know, there's not a lot of tax guidance out there about crypto issues in general. And then when you try to turn to the tax issues that affect a situation like this, there is truly nothing out there. And so, I want to give credit where credit's due to the folks at White & Case that have been, working hand in hand with us at Kirkland to get to the best possible tax answer that we can for all of you. And we understood how important that was. I wish that I could tell you that I could get to a tax-free treatment to everyone and that, no one would have any tax consequences as a result of this transaction. I know it seems almost perverse that you could find yourself in a situation that you're in where, you have lost as a result of this transaction, but the tax rules say, oh, by the way, you have a tax liability. And, if I was king of the world, I would make that not be the case. And I actually reached out to IRS, Treasury, wrote papers, did articles, did presentations, trying to get some semblance of order into this market, by the way, all of which, we did not bill for those presentations and articles and all of that type of stuff, but we were trying to bring order to what is kind of a little bit of chaos on the tax side here. And we've done the best that we can. It does mean that, consistent with the disclosure statement, there's going to be a tax event to the extent that people are getting stuff other than the type of cryptocurrency that they deposited on the platform in the first place. And, unfortunately, that's just, we weren't able to get around that fact. But that fact did drive some of the thinking on how, people were approaching a lot of the issues in this case. So, that's kind of, I encourage people to read the tax section of the disclosure statement. I know it's hard. I know it's thick. I would draw people's attention in particular to, I think it's page 305 of the disclosure statement, that has as simple of an example as I could come up with to try to guide people a little bit on how you might think about how much of your recovery is taxable and how much of your recovery is non-taxable. And that discussion is in the context of convenience claims, but then you'll see that the discussions in other sections kind of refer back to it. So that's kind of, where I would guide people to in the first instance. And with that, I'll kind of pause and address some of the questions that have come up here.
Great, thanks, Anthony. So the first question we had on tax, is Celsius going to send account holders year-end tax forms reporting the value of the returned Bitcoin and ETH and or the value of NewCo equity as reportable income?
Okay, so the answer to that, we believe, and we're continuing to look at all of the different kind of tax reporting regimes that could come up here, but we do not believe that there is, at least right now, a regime that would cause us to send tax forms to people kind of stating the value of what you got under the plan, how much income you might have under the plan. There just aren't any tax forms that speak directly to it. And right now, preliminarily, we think that will be true even if Treasury ends up releasing the pending regulations that deal with transactions on cryptocurrency exchange and similar platforms. Because this transaction is not a transaction that's occurring on an exchange, it's a transaction that's effectively with the exchange. And we don't think that the regulations are going to cover that. There are some other kinds of tax reporting constructs that we looked at that also, we do not believe apply to this situation. So the information that you're going to have from the company is going to be what's in the disclosure statement. And it's going to be also the kind of ordinary course reporting that you've been kind of getting with respect to yield and things of that nature. But for the plan itself, we don't think there's going to be a separate set of 1099s or anything of that nature.
Great, thanks. The next question is, if we receive a distribution in Bitcoin or ETH, it's not what we had on the platform, will Celsius provide a sell date for the coins we had specifically so we can have a convert date to report to the IRS?
Yeah, so this is an area where, and believe it or not, although I don't post on Reddit, I do read the stuff on Reddit to try to get a handle on, okay, here are some of the tax misconceptions are so that I can do my best to address them. In our view, although it's not free from doubt, and all of this is qualified in full by what's in the disclosure statement. We went into greater detail in the disclosure statement. And we're not providing tax advice directly to any of you. But in our view, the right way to think about your relationship with the company is that when you deposited your cryptocurrency on the platform, you no longer have, from a tax perspective, a direct interest in that underlying cryptocurrency. What you have is a claim against the company for the return of the cryptocurrency that you deposited. And I know that sounds like semantics, although I know that it's driven a lot of non-tax issues in the case as well. But from a tax perspective, what that means is that once the coin is on the platform, what the platform does with the coin is not relevant to you from a tax perspective. So what you have is the claim against the company. That claim is generating yield, which is why you got 1099s with respect to yield. You are not getting 1099s with respect to the actual interest that the company was earning with respect to the coin. You were getting 1099s with respect to the contractual entitlement that you have against the company. So you deposited Ethereum, company sells it for Bitcoin. That has no consequence on you. Then the company sells the Bitcoin for Ethereum again on another day. That has no consequence to you. What you have is a claim against the company, and your tax basis in that claim is the same tax basis that you had in the coin that you put into the platform in the first place. So if you deposited one Bitcoin with the platform and you bought that Bitcoin for $100 10 years ago, and I'm incredibly envious of the people that did that, and what you have after having deposited that Bitcoin is a claim against the company for the return of that Bitcoin, and you have $100 of tax basis in that claim against the company. From there, when you get the distribution under the plan, That's the taxable event. Okay, so the taxable event is the day that you get stuff, not anything that's happening on the platform. And so you have this claim against the company for the return of 1 Bitcoin, and you had $100 of tax basis in that claim. And on the effective date of the plan, you get a combination of cash, Bitcoin, and NewCo stock. All right. Your tax event is on that day that you get the cash, stock, Bitcoin, and that's the day that you say, you got a certain amount of value in exchange for your claim against the company. Part of it is taxable, the part that was cash and equity in NewCo. Part of it is tax-free, the return, the receipt of the Bitcoin in exchange for, the claim that you had to get the Bitcoin back. So I hope that helps to kind of deal with some of the uncertainty on this issue. It's not kind of a rolling determination. Effectively, the tax consequences on the day of the plan itself.
Thanks, Anthony. The next question we had is, how will the NewCo equity be taxed? Is it going to be taxed as ordinary income when the creditor receives the equity?
Yeah, so the answer to that is, again, kind of caveating to the disclosure statement. Most people, I expect, treating their underlying cryptocurrency as a capital asset. People that were treating the cryptocurrency as a capital asset should probably, subject to getting your own tax advice, be treating the claim against the company as a capital asset. Then when you receive NewCo stock in partial satisfaction of that claim against the company, that's going to be capital gain or loss, depending on that NewCo stock relationship to the tax basis that you had in the underlying claim. That might be income. If you had very low tax basis in your claim, it might be loss if you had high tax basis in your claim. But for most people, it's going to be capital. And, candidly, for the folks that it's not capital to, that is a sophisticated group of people that probably, are certainly in a position where they should be, obtaining their own tax advice. Everyone should be thinking of it individually, but anyone that might be treating this stuff as ordinary income, that kind of means that you're partly making a business out of this. So we expect that for most people, subject to all the caveats of the disclosure statement, it will be capital gain or capital loss. And then from there, you have stock, and it's treated like any other stock. If you get dividends on that stock, it may be taxed as a dividend. It may be taxed as a capital gain or loss. It just depends on the status of the company when that cash distribution is being made. But I expect for the most part, the receipt of the stock for people is going to be a capital item in either gain or loss.
Great. And then the last question that we had submitted on taxes: how should creditors treat cryptocurrency loss through the bankruptcy process? Is this a capital loss? Is it a theft loss? How do you address that question?
Yeah, so let me say a couple of things on this. In general, and as we said in the disclosure statement, we kind of think of this as a capital item for most people. You had tax basis in your claim against the company. Let's say you had high tax basis in your cryptocurrency. Okay, so you bought cryptocurrency when it was at 60,000 or 50,000 or 40,000, whatever it may be. And then you deposited that cryptocurrency on the platform. So you had $40,000 of tax basis in your claim against the company, and what you get back is $20,000 worth of stuff. And so you're sitting here thinking, like, on a tax basis, you have $20,000 of loss, some of which might not be recognized to the extent that you're getting an in-kind distribution of the same type of cryptocurrency, and some of which will be recognized to the extent that it's taxable. And we view that as a capital transaction. We completely understand that there are some theories out there in the world that would say that there is some kind of theft loss or similar kind of casualty loss to be taken under the circumstances. Okay. And, I am not an expert on state theft law. And fundamentally, the tax analysis that goes into whether you can claim a theft loss ties back to state common law theories of theft and misappropriation and things of that nature. Our view of this situation has been that, we kind of didn't believe that that was the right treatment under these circumstances. And so that's not how we have been thinking about it. And that's not how we have disclosed things in the disclosure statement. I am by no means saying that it would be an impossible position for people to take. You need to consult with your own tax advisors if you think that you want to claim that position under these circumstances. As with everything here, it's fundamentally you need to consult with your own tax advisors. But I would urge caution. If you believe that you can claim a theft loss under these circumstances, and I would make absolutely sure that you're getting independent tax advice so that you have a good basis to make that position with respect to the tax returns that you're filing.
And I think that's really important. We've approached this, or Kirkland has approached this from a very, broad base, looking at the tax treatment as a whole. But everybody's position's different. And Anthony pointed out people that bought at 50,000 versus people that bought at 1,000, and I'm referring to Bitcoin prices there, may have very different effects through this plan. And we are trying to structure a plan that takes that into account. So one of the provisions of the plan provides that if
So Anthony, if I heard you correctly, my interpretation was you wouldn't feel comfortable giving tax advice to this many people with disparate situations formally in the form of a disclosure statement, but you wouldn't rule out the possibility of taking this tax position provided you sought out an expert.
Look, so just to be clear, right? I can only give tax advice to my client, and my client is the debtor, right? So I'm not giving tax advice, and the disclosure statement doesn't actually constitute tax advice to anyone. It constitutes kind of our kind of view of what we believe the appropriate kind of way to treat things is. So I can't tell you that I would rule out taking any position. Okay, that's a kind of matter for you and your own tax advisor. I can tell you that we didn't think that was the right treatment to disclose in the disclosure statement because we didn't view it as kind of the better treatment. But I would not sit here and say like the debtor is saying that it's impossible to take any particular tax position with respect to theft loss, casualty loss, things of that nature. But it's not what we set forth in the disclosure statement based on all of the information that we've been able to kind of gather. And we have no agenda there, by the way. I acknowledge that I've seen some of the verbiage out there that says like, well, of course, Kirkland's not going to say that someone can take a theft loss because what does that mean in terms of the stuff with Mr. Mashinsky and so forth? That's not the basis of this disclosure. That's not the basis of what we've put down. That's not what we're doing when we set this forth. It's just that having, taken a look at the facts in this particular situation, and you might, if you have deposits on other cryptocurrency platforms, one might get to a different conclusion, right? But for the facts that we have here, including everything in the examiner's report and all of that, we just didn't think that was the right treatment to set forth in the disclosure statement as what we thought was kind of the most likely one. Does that help? I know it's kind of a lawyery non-answer answer, and I have to be a little careful because again, you're not my client, but that's kind of the best way that I can answer your question.
I think I understand. It's a high standard to reach, to put into a disclosure statement that's going to reach many creditor, hundreds of thousands of people who are not your client.
Yeah, that's right. And taking a theft loss, by the way, is also a high standard. Okay, if you look at the authorities that are out there about that, that's why I'm urging caution. It's not an easy standard to get to.
All right, Scott, can you hear me?
Do we have any more questions? Oh, go ahead.
Scott, can you hear me? I'm not sure my headphones are working.
Do we have any more tax questions?
You might have dropped Scott down and bring him back up.
I'm sorry?
Scott, can you hear me? Or can anyone hear me?
Yes. Hey, Aaron. Yes, we can hear you.
Okay. So I'm not sure that Scott can. Our next section was supposed to be the question and answers, and Scott was going to.
Okay. I had one more question. Will the app reflect the tax situation, basically like a sell at the petition date price, if you're using software that tracks it?
That's not a question that I can answer. I'm sorry, and it's not that I know the answer. I'm not saying it. It's that I'm not sure what the answer is. But kind of going back to something that I mentioned earlier, our view is that you didn't have a sale on the petition date, right? You had a non-taxable deposit when you put the cryptocurrency onto the platform. The petition date was a nothing from a tax point of view, and your tax event occurs kind of on the effective date of the plan when you get the distributions. And again, you're not doing a transaction on the platform, you're doing a transaction with the platform. But beyond that, I'll have to kind of speak to some other people and see whether there's a way that we can respond to that in another forum. I'm sorry.
All right. I think Scott was having a bit of difficulty hearing me, so I dropped him off and pulled him back up. Scott, can you hear me now?
I can. There you are.
All right, Scott. So we've gotten a number of different questions, and I was going to toss it to Scott to ask those. Do you want to start with the PayPal question, Scott?
Yes. Let's talk about distributions. We got a significant number of questions related to the use of PayPal as the means to make cryptocurrency distributions in the United States. Let's start with, will PayPal be used to deliver distributions to account holders for United States-based creditors and international creditors?
So PayPal is going to be used for cryptocurrency distributions to U.S. retail customers only. As we stated in the disclosure statement, the debtors are in discussions with several entities to handle international distributions and corporate distributions. And we're hopeful that we'll be able to announce something soon, and that we're getting to a point where we can announce something soon. So please stay tuned for the international front there. I think in a couple other questions, we'll talk about distributions through the Celsius app, which I think we've gotten a bunch of other stuff for, but I'll hold off on that for now.
So how will account holders without PayPal accounts receive their coin distributions?
So account holders in the U.S. are going to have to sign up for a PayPal account to receive their cryptocurrency distributions. And if you don't like PayPal, if you don't think it's a good company, you can open up an account, take your cryptocurrency off, and then close your account right after that. If you are unable to open a PayPal account for any legitimate reasons, we are hopeful that our international solution may be able to work as a backup provider. If that does not work, we're going to have to figure out a way to send probably a check to people.
Why was PayPal chosen?
So we, the debtors went through a big process to search for the distribution agent, and PayPal offered the best terms. Quite frankly, it was significantly less expensive than other options. PayPal also has a complete set of licenses in the U.S. other than Hawaii for transmitting cryptocurrency. And they have licenses in over 200 countries to transmit fiat currency. They're one of the few entities in the world with that level of coverage. And so they give us they give the debtors a very wide breadth to transfer both cryptocurrency and fiat if necessary to all of its customers.
And is there any alternative to PayPal currently being sought?
So that's what I just mentioned. The debtors are currently looking for a third-party distributor to handle international distributions and corporate distributions. And I think that they're getting close there, and we're hopeful that we can announce that soon.
Okay. And the biggest question I've seen is about the $10,000 withdrawal limit. Will that be applied to Celsius distributions?
So the debtors have asked that of PayPal, and we understand that PayPal's leaning in and trying to address that issue. Now, the $10,000 limit is a limit that is required by law. It's a limit it's a safety protocol, and it's meant to protect accounts from being hacked or from making distributions to the wrong person. And it's a law and a regulation that doesn't just apply to PayPal. It applies to every single cryptocurrency exchange, every single bank. And, that's why when you make a big withdrawal, you have to provide that additional AML KYC, whether it's holding up a picture, whether it's proving your identity some other way. And so this is not a PayPal requirement. And we understand that PayPal is working on a solution to address that. And we know it will have to be addressed because the nightmare scenario that some have painted out, where they say, I've got, $1 million on Celsius, or I'm going to get $1 million, and I'm going to have to every single day go on to PayPal and take $10,000 off. It's not something that we want to have happen, and it's not something that PayPal wants to have happen. So we understand that they're working on that, and we hope that there is a solution to that soon.
And I guess a follow-on to that is, if you are withdrawing $10,000 per day, are you being charged fees for all those withdrawals?
Well, I hope that no one's withdrawing $10,000 a day, but the answer is no. PayPal is not going to charge any fees on a withdrawal. If you want to use a PayPal service, for instance, if you receive Bitcoin and ETH and you want to use PayPal to sell your ETH and get more Bitcoin, you'll incur PayPal's normal fee for that, but there will be no withdrawal fees from PayPal.
Okay. And why can't Celsius just distribute through the app?
So Celsius can distribute through the app, and it has distributed through the app with respect to the custody distributions. But we think it's going to be prohibitively expensive for that to do so. So if you think about it, to make transfers, Celsius needs to retain a security team, an AML KYC team, a coin management team, and it's going to need to retain those for the period in which it's making those distributions after the effective date. And so it's going to have to pay those folks, and then it likely will have to incentivize them to stay on because they will know that at the end of that, there will be no more Celsius. We think that that's going to be, very expensive, and more expensive than if we used a third-party provider. And it will necessarily have a sunset provision because at some point we'll need to shut the Celsius app down. Versus if we have a third-party provider, we can ensure that people are able to get cryptocurrency distributions for a longer period of time. And here, we've tried to minimize holdbacks as much as possible, but there will be some holdbacks. And so by using third-party providers, our hope is that we can make it so that those holdbacks for liquid cryptocurrency, customers can receive liquid cryptocurrency.
And then what about the NewCo shares? How do we get those?
All right. So as Joel mentioned on Monday, we're in the process of engaging one of the major transfer agents that does distributions of shares for NASDAQ companies to the US and internationally. And we're finalizing the agreement with them, and we hope to have that documented soon. The intent is that NewCo is going to list its shares on NASDAQ. And as part of that process, NewCo is going to file a Form 10 with the SEC once it's completed all of its audit requirements. We anticipate that Form 10 is going to be submitted before confirmation so that we can be ready to emerge with the Form 10 issued and effective. I believe that typically once you submit the Form 10, there's a 60-day period in which the SEC can review it. And once that Form 10 goes effective, then you can trade your shares. And you can trade those shares in a private transaction. Once we get to NASDAQ, your broker will be able to initiate a direct registration system or a DRS transaction to move your shares from the transfer agent to your brokerage account so that you can sell them. The shares are going to be issued in a book entry form, and they get recorded on the transfer agent's master share register. So the way that works is Celsius, when we emerge from bankruptcy, it will give the transfer agent a share register that says what shares each individual creditor owns. And then the transfer agent will send you a statement reflecting the amount of shares you received from the debtors. Now, the holdbacks that I referred to with respect to cryptocurrency, those are also going to occur with respect to NewCo shares. If there are disputed claims, we need to make sure we have enough shares held back so that we can give those to people as claims are resolved. And so Celsius, as claims are resolved, will continue to update that share registry, and the transfer agent will continue to send you statements updating your shares as claims are resolved. Once the shares are with the transfer agent, you own the shares, and you don't need to do anything else to own the shares until you want to sell them. To sell those shares, you need to act through your registered broker-dealer, and that could be Robinhood, JP Morgan, E-Trade, etc., and ask that broker to communicate with the transfer agent to move the shares to your brokerage account. And then once in the brokerage account, you can then trade them. And I know I have a banking app. I look at that to see what my positions are. And so you may want to move your shares to your brokerage account before you trade them. But as I said, once they're with the transfer agent, you own those shares and the shares are yours.
And this is what would happen with unclaimed claims? How do those get distributed to creditors?
So if we've got a lot of property that people have not picked up, what the plan provides is after 1 year of the first attempt to deliver, those distributions are going to be declared unclaimed. Now, with respect to NewCo common stock, the shares are going to revert to NewCo, and it will be up to the board what they do with those. With respect to cryptocurrency, they're going to go to the litigation recovery account, and from there they'll be distributed pro rata to holders of claims. And the thought in sending them to the litigation recovery account is not to fund the litigation recovery account in any way. Instead, the thought was people may trade their NewCo common stock. And so if we were to send the liquid cryptocurrency to NewCo, you might not be sending that to creditors. Whereas we think there's a smaller chance that people will trade their litigation proceeds. And so by sending it there, we will ensure that more of the liquid cryptocurrency that's unclaimed gets back into creditors' hands.
And so just a request from me to the 500 or so people on this Twitter space, if you know somebody who is just not, up to their eyeballs in this bank bankruptcy case and out there living their life, please get a hold of them, ask them to fill out their ballot, and make sure that they claim their distributions.
Absolutely.
How does voting on this plan work?
All right. So, as I said, we're going to be releasing a video on this where I click through the ballots. But everybody should have received a ballot or will be receiving a ballot to vote on the plan of reorganization. Once you fill out your ballot, so when you get that email, I guess I'll take a step back. When you get that email, the email will have a bunch of different things on it. A lot of it is links to the solicitation package. And I think the two most important documents there are the plan and disclosure statement. And in the table of contents to the plan, there's Kirkland tried to put together, the 65, 70 most common questions and most important questions. And so if you have a question, first place to look is that to see if it's answered. There's also a letter from the committee explaining why we support the plan and why we think that creditors should vote for the plan. At the second part of that is a link to submit your ballot, and it contains a unique PIN to you, which you can type into the Stretto site, which will pop up your customized ballot. And then the ballot has a number of different items that provide the different elections that you may make in the plan. Once you're done, and I believe it's item 9, which has your choice whether to vote to accept or reject the plan, you click submit and you'll receive a confirmation code from Stretto. And as I said before, the deadline to make sure you submit your ballot is September 26th. On September 25th, Stretto is going to file a notice disclosing how creditors voted on the plan. And from there, we're going to move to the confirmation hearing. Now, for a bankruptcy plan to proceed to confirmation, at least 2/3 in dollar amounts and 1/2 in number of creditors and at least one impaired accepting class must accept the plan. If all creditor classes don't vote to yes, the debtors can seek to cram down the plan along the lines set forth in Section 1129B of the Bankruptcy Code. And under the Cram-down standards, the court can approve the plan so long as it treats dissenting classes fair and equitably, and it does not discriminate against those classes of creditors, which are both legal terms of art that have been litigated, for a very long time. So what the fair and equitable and discrimination provisions provide and make sure is that a dissenting class of creditors receives its legal entitlements, but they can't hold up confirmation for a plan that's otherwise accepted by other creditors.
And for those creditors that are subject to avoidance actions over the $100,000 threshold, how can they pay the 27.5% proposed settlement? Is there a way to agree to the settlement and have it net against your claim?
Right. So the avoidance actions I know are a hot button issue. And on your ballot, there's going to be, I think it's item 2, it lists all of your claims, and it also is going to list your withdrawal preference exposure. And the debtors have included how that amount was calculated on page 76 of the disclosure statement. So to participate in the avoidance action settlement, you must vote your claim in favor of the plan, and you have to not opt out of the releases. For individuals with preference exposure under $100,000, avoidance action will be released on the effective date. For individuals over $100,000, you will need to make a payment equal to 27.5% of your preference exposure to opt into the settlement. Now, on the ballot, I forget which specific item this is, but we put a checkbox which indicates if you're interested in setting off your distribution against if you want to make the 27.5% payment. Now, right now, it's impossible for us to say whether you will be receiving enough liquid cryptocurrency to fall in that, because how much liquid cryptocurrency you're going to receive is dependent on what the price is closer to the effective date. And I know that we've gotten a lot of questions about how we're going to calculate what you receive. There's a concept in the plan, I believe it's called the distribution recovery table. I'll get the specific term. But that will tell, that's going to be calculated 15 days before the effective date. And that will say how much Bitcoin or ETH everyone's going to get. And at that point, I believe the debtors will be able to reach out to those that have clicked and indicated that they're interested in setting off their claim and see if they are still interested. Now, at this point, the debtors are not asking for any payment on account of the avoidance action settlement. To the extent the plan is confirmed and we move forward, we will reach out to every single person that qualifies for it and ask if they are interested in participating and provide instructions for how they can participate. So more to come on that as we get closer to the date of the effectiveness of the plan.
And for the purposes of the weighted distribution election, more commonly known as the Tony toggle, what prices will be used? The crypto prices as of May 31st, 2023, or a later date?
So again, I'm going to refer to that concept of, it's called the distribution cryptocurrency conversion table. That's the defined term in the plan. And that is what is going to be used to calculate distributions. And the plan indicates that it's going to be released 15 days prior to the effective date. Our goal is to calculate that close to the effective date so we can make sure we're as accurate as possible in distributing amounts to creditors while allowing a period so that we can make sure that that we can operationalize everything. So I would assume that is going to be the amount that's used to calculate how much goes for the weighted cryptocurrency distribution election. And, I know it's been talked about a lot, but the weighted cryptocurrency distribution election, it can only be satisfied if there are people on both sides of the trade. And borrowers, part of the negotiated out mediation, borrowers will get first priority to elect more liquid cryptocurrency. If it's not completely filled up, I would expect that those that elect to receive more liquid crypto will try to spread it pro rata equally out amongst those folks that will make that election.
For confirmation voting purposes, 2/3 of class value voting, how will claims containing CEL token be valued at 25 cents?
That's right. So the debtors intend to use the 25-cent settlement for plan voting purposes. However, we put in the plan that, we understand it may be a contested issue at confirmation. And if the court determines that the token's worth something different, we'll have to calculate the votes based off of that difference treatment. So if the court determines the token's worth 0, we'll have to recalculate the votes. If the court determines the token's worth 81 cents, we'll have to recalculate the votes based off of the number the court finally determines.
When will the litigation administrator begin negotiations with those subject to clawbacks so they can get their distribution?
So the litigation administrator does not exist and will not exist until the plan is confirmed and goes effective. So we would anticipate that those negotiations will occur after the effective date, and we've included ADR procedures to help speed those along. And the thought of the ADR procedures is that those are more efficient than litigating every single claim in the bankruptcy court, and will provide an efficient mechanism to do it that's both more cost effective and more efficient to work through that process quicker. The ADR procedures, they're a multi-step process. And as we said at the hearing, we understand that certain individuals have objections to the ADR procedures, and we intend to talk with those individuals to try to come up with a set of procedures that can work for everybody. We will file whatever agreement we're able to reach or amended procedures in the plan supplement, which I believe is to be filed on September 8th.
For creditors that wish to vote no to the plan, is that accomplished by opting out of the plan?
So I'm not sure what this question asks in terms of opting out, but to vote no on the plan, you actually need to vote no. If you don't vote, it's not counted. And so when you count the amount of people that accept or reject a plan, you only count votes that were actually cast. So abstaining is not counted as a no vote.
And just for more clarification, a no vote to the plan is not a yes vote for an orderly wind down. Is that correct?
That's right. This is a whole transaction, and you vote to accept it all or to reject it all. And I guess I'll just point out, if the plan does not get confirmed, it is not certain what is going to occur after that. And it will be much longer before we're able to make distributions to folks.
Because we would have to get an entirely new disclosure statement approved.
And an entirely new plan.
Yes. If I vote no, opt out, and the plan still passes, do I get to participate in the plan recovery?
Yes. If you vote no, but the plan still passes, you will get the recovery provided under the plan. I guess there are a couple important exceptions to that. One is with respect to custody claims. So a vote, there was the custody settlement that was entered into, and you can still agree to that custody settlement by voting your custody claim to accept the plan. And if you look at the ballot, you're required to vote all of your claims to either accept or reject, with the exception of custody claims, where you can vote them separately whether to accept or reject. So to state it more simply, if I have an earn claim and a borrow claim, I can't split my votes on those. But if I have an earn, a borrow, and a custody claim, I could vote my earn and borrow claim to accept and my custody claim to reject. And the reason that that option is there is because voting a custody claim to accept opts into the settlement, whereas voting a custody claim to reject, you do not opt into the settlement, but you will, your distribution and your cryptocurrency will be placed in a reserve, and you'll have to work with the litigation administrator as to how he's going to address your potential avoidance action exposure. And so that's the one instance where voting no, you would not receive the treatment that is provided to all other creditors in that class.
And so then, can I elect to be classified in the convenience class for earn claims and elect different treatment for my loan account?
So I think what this is referring to is the convenience class election. And what that election is if you've got a earn claim and you say, I don't want to receive liquid cryptocurrency, NewCo stock, and litigation proceeds. Instead, I want to receive the convenience class treatment. There's an election where you can do so. However, if you make that election, your claim is reduced to the $5,000 convenience class level. So say you've got a $10,000 earn claim and you want to make that convenience class election. If you make it, you won't have a $10,000 earn claim. You'll have a $5,000 earn claim, and you'll receive the 70% liquid cryptocurrency distributed to that convenience class. Now, you don't get to make that election for each different type of claim you have. It's made on an aggregate basis. So if you've got a stub claim on your loan claim and an earn claim, and you make that election, all of those amounts are going to be reduced to $5,000, and you'll receive the convenience class treatment for those claims.
And Aaron, just to make sure, when you elect that, all of your claims are your total claim amount for everything is just $5,000.
Correct.
Okay. And what are our options for receiving solely crypto in kind?
So the options are, one, to make that convenience class election that we just talked about, or to elect to toggle your recovery. And if you elect to toggle your recovery, as I said, it's not certain that you will receive all cryptocurrency. We will satisfy it to the extent there are people on other sides of the trade, and so that is a way to receive potentially more cryptocurrency. And if a lot of people elect to receive the stock, or we're able to find another way, electing that may get you all of your distribution in cryptocurrency.
Are multiple loans considered separately or consolidated and treated as one?
So I believe they're going to be treated as one under the plan in terms of your vote, but they may maintain their separate character for tax purposes.
Is a loan's principal subject to retail clawback?
So I'm not sure I quite understood this question, but under the plan, a loan, it's called a retail advance obligations, the defined term. And the plan provides for two different options for borrowers. They can either pay that amount back to the company and receive Bitcoin and ETH of an equal amount back, Bitcoin or ETH, at their election. And the purpose of that related to Anthony's comment earlier, that it may provide for some tax benefits. But you should consult your own tax advisor as to whether that is appropriate or advantageous for you. The other option is to receive the set-off treatment, and under the set-off treatment, you do not have to pay anything back, and your loan or your principal obligation will be reduced from your retail borrower deposit claim, and you'll receive treatment on that excess claim, which under the plan is called the post-set-off obligation.
And will individuals with large-sized exposure to loan and or preference payments be able to directly negotiate a settlement agreement within the voting period?
So, as I said before, the settlement that's offered under the plan is the avoidance action settlement. After the plan is confirmed and goes effective, the litigation administrator will be able to discuss potential settlements with anyone that doesn't want to accept those settlements.
And we've gotten a lot of questions on XRP and Flare. Will Celsius release Flare airdrop to XRP holders? And if so, when will this happen? So
the Flare issue has been outstanding for a while, and I know we receive questions on that every time we hold a space. I spoke to the debtors yesterday, and I believe that they are in conversations with Flare about how Flare will be treated. And I believe they've been in conversations with Flare for quite some time. So I don't have a definite answer on that, but I can tell you that the debtors have continued to talk to the people at Flare about how to get those coins either to the estate or out to creditors. And so I don't have a concrete answer at this time, and it's in part because I believe those discussions are being had by someone other than myself, and I believe that they are still ongoing.
We touched on the valuation of CEL in the plan at 25 cents. Will we make any exceptions for those who bought CEL on the open market?
No. The valuation of CEL token is for all CEL token deposit claims. So that's claims on account of CEL in accounts on the platform. And the current settlement provides that those will be valued at 25 cents.
Changing the subject a bit, some account holders have inquired about how distributions will be processed for those holding crypto for retirement purposes. For example, can I receive my crypto equivalent distribution in cash sent to my retirement account at the bank? Who's the custodian?
So this one, I think, is a pretty particularized question. I am not sure. It's pretty complicated because I'm not sure that there are IRAs that can receive crypto, and some IRAs even cannot accept stock. So I think it's pretty individualized. But if you have this specific question, I would recommend that you reach out to the debtors so that they can try to see if there is a way that they can make sure that you get your distribution and are able to pick it up.
And how does the plan categorize United Kingdom-based individuals with loans, even though Celsius initiated repurchase agreements after UK regulators advised Celsius to halt loans?
So all loans are treated the same under the plan, and they are going to be all classified in Class 2 as retail borrower deposit obligations. Does that take us to the bottom of the list of submitted questions, Scott?
I believe those are all of the questions that we have.
All right, so we're at about an hour and a half, but I know that a lot of people have some questions. So, Scott, if it's okay with you, maybe we can stick around for 15, 20 minutes more and take a couple, and then we can, folks can digest this and send us emails. As I said, the email address that we used for this Twitter town hall is the email address where we've been collecting creditor questions. So if you have additional questions, please send them over, and we'll try to answer them either in this forum or try to find a better forum in which we can answer them moving forward. So with that, I will try to pull some people up. Liberty Lover, I know you've had your hand raised for a while. Can you hear me, and are you there?
Hey, yeah, thank you. I am here. Quick question on FTX. What specifically did FTX do that is causing Celsius to file a $2 billion lawsuit against FTX?
So I'm not going to get into confidential information. I guess what I will say is that Celsius filed a claim against FTX, and that claim asserts a number of different claims and causes of action against Celsius or against FTX, and it was required to be filed because the bar date was occurring in the FTX case, and so it had to be filed in order to preserve those claims. And I understand that both Celsius and the UCC are investigating those claims, and we'll have more to come on that. But again, I don't want to get into confidential information at this point.
I see. So is it possible in the future that that information can be released to Celsius creditors for us to understand what exactly happened?
Like all litigation, I believe that we should let this one play out through the litigation channels in court.
I understand that completely, but I guess is there a legal possibility for us to know what happened eventually at some point?
I mean, the examiner's report details a little bit of this, but as with all litigation, right, it's public, and to the extent that that claim moves forward, it will move forward in a public court-focused manner.
Okay.
So I appreciate the question.
Thank you.
Thank you very much. At this point.
Hey, Aaron.
Uh-huh.
I saw just a question in the comments. If to receive distributions, if a creditor accepts the plan, pays the clawback, can they then participate in the negotiation after that?
I'm sorry, could you say that again, Scott?
If a creditor votes to accept the plan, pays the clawback settlement amount, could they then, after the fact, negotiate the clawback?
No, the paying the settlement amount would be settling the claim for that amount, so that would be final.
Okay.
Joe Lair, are you there? Joe, can you hear me? All right, I will pull someone else up while Joe might jump on. How about Buckeye Doe? Buckeye, are you there?
Hi, yes. I still have yet to receive my email ballot from Stretto, and I've confirmed that my email on file is the correct email. Um, what should I do in this case?
So on the Stretto website, at the top of the kind of ribbon, there is, I believe it says balloting. I'm trying to look for it now, and I might not be finding it, but I believe that if you click on that balloting link, that you can enter in your email and they will resend it to you.
So I did that yesterday, and it was over 24 hours ago, and I got confirmation on the site that it said I should be receiving it shortly, but in over 24 hours, I haven't received anything. I've checked spam, I've checked everything, and I still don't have anything.
So what I would do is to email the Stretto website,
Okay.
and you can copy me on that email. My email address is in the bottom of all of the pleadings.
Okay.
But I believe that I'm looking for their email address. It's celsiusinquiries@stretto.com. And they should be able to make sure you get that. But that is something we need to resolve, because you shouldn't have to wait for 24 hours for someone to get you back your ballot.
Okay. Thank you.
You got it. Crypto KPR, are you there?
Oh, is that me? I'm sorry, I didn't hear.
Yes.
Hi. Yeah, I got a question. I don't know if this was covered. I came in a little late. What is what is the actual distribution for earn? I mean, we've received a lot of different types of percentages that have been thrown out to us. Are we actually going? So there's two parts of the question. The first part is, are we going by petition date pricing or no? And then the second part is, what is the actual distribution to earn? Will borrow actually receive a higher distribution than earn, or what is the break mix?
So I think there's a number of different points in your question. The disclosure statement provides an estimated percentage of your claim. And for earn, I believe it's 67%. Now, you asked about petition date pricing versus effective date pricing. And it's important to understand that the petition date pricing and the petition date price of coins determines your claim, which is your share of the pie. However, cryptocurrency is not where it was on the petition date. So what you actually receive in terms of coins as a percentage of your claim will be determined based off of the price of cryptocurrency on the effective date. And so it's not as if we're going back and saying, we're setting the assets of the debtors at the time of the petition date. Rather, that's when your claim's set, which establishes your amount of the pie. And then what you receive of that amount will be based off of the value of the assets. And as I said before, we're using that distribution conversion currency table, which we anticipate will be about 15 days prior to the petition date. Now, for borrow claims versus earn claims, this was the subject of the mediation, and the treatment provided in the plan for a borrow claim, as I said before, treats the principal obligation of that claim so that you can either repay and get an equal amount of Bitcoin and ETH back, or accept the set-off treatment and not have to repay your loan. And then that excess portion is treated the same as earn claims. So it will receive a pro rata share of the liquid cryptocurrency, Bitcoin and ETH, the litigation proceeds, and NewCo common stock. Thanks very much for the question. Brandon Russ, are you there? I'll bring up Joseph Padisal too, if you were there. Either Brandon or Joseph, are you guys there?
Hey, this is Joseph.
Hey, Joseph.
Hey, thanks for taking my call. I have really been stressed out about this one point, and this is an issue I don't think has ever been addressed, but I am an Apple login user. I do not log in with an email and a password like everyone else does, and I am being left out of the voting process. I've been sending emails. They seem to be going into the abyss, and I am very worried about this. And even furthermore, I'm worried about distribution afterwards because I've never received one email from Stretto during this entire time period. And, and I've going back to an earlier point you made about, I have to say, if there was any consideration to try to let distribution still happen on the app, that would be great.
Is Joseph Padisale your full
It
name?
is.
Okay, let me email the debtors and Stretto about this, and I will hope to get back to you. And if you want to send me an email after this, so I have your email address. I don't want you to disclose that to everybody.
Yeah.
But if you send me an email, then I can hook you up with the debtors.
What email can I write to you at?
Yeah, so it's my first name,
Yep.
Aaron.
Yep.
Period. My last name, COLODNY at whitecase.com.
Okay, thank you so much. So it's just aaron.colodny at whitecase.com.
Correct.
Yeah, there's a ton of people on Reddit that are in the same position, and everyone's worried. So thank you.
Well, look, it's something we need to address, so I appreciate you raising it, and I will make sure it gets through the
Really appreciate it. Thank you so much.
You got it. Brandon, are you there? How about Zach Larson? Zach, are you there?
Can you hear me?
Yep, got you now.
Oh, this is Brandon.
Oh, hey, Brandon.
Sorry about that. I just had a question. My ballot says that I have clawback exposure. The only reason I'm over 100,000 is because I withdrew the proceeds from a loan. Does it make sense that I'm being clawed back on the proceeds from a loan, as well as being offset for the my collateral being offset?
I'm not sure about that off the top of my head. I will say that I think it's at page 76 of the disclosure statement. The debtors listed how they calculated that preference exposure, avoidance action exposure. And so if you look there, it should help you out. And if not, I would contact the debtors at the Kirkland email address, and they will be able to get to the bottom of that a bit easier than I can.
Okay, the Kirkland email address. Yeah, because that's exactly what's happening to me. I'm being clawed back for the loan as well as being offset.
Great. So if you... Sorry, Scott, were you going to say something?
Well, I just wanted to make sure I understood. Are you saying that you took a loan and they're considering the taking the loan principal to be subject to an avoidance action?
Yes, I withdrew the principal, after taking the loan, and I'm being clawed back for the principal.
All right. Well, why don't you, you can copy me on the email, but I would email the Kirkland email address, and I think that's probably the best way to get to the bottom of it.
Yeah,
okay.
I just add, happy to sort of look into it as well. The loan transactions are a little bit complicated depending on from where the collateral or principal, where it was sourced, whether it came from, say, earn or custody. And it sounds like I'm not sure if you're talking about multiple loans when you talk about sort of the set off, if there's something still outstanding, or loans that were issued or repaid over the preference period. But happy to look into it and walk through it with you.
Okay, so I email the Kirkland address, and anyone else?
You can copy me on it, Aaron, and I'll hopefully try to get to the bottom of it, or at least help you get through the process.
Okay, thanks a lot. Appreciate it.
Of course. Tony, you're up.
Hey guys, how's it going? Aaron, Scott, Tom, Ken.
Pretty good. How are you?
I'm good. We're hanging in here. So I got a question that a lot of people have. I've been answering it, but no one seems to believe me. So it's probably better to come from you guys. If a third-party option is available to refinance the loans, does a borrower need to vote yes for the plan so they can elect to get all crypto, or can they abstain?
So I think the question, Tony, is about the toggle, right? Which yeah, I've always thought the Tony toggle was named after you, but I might be wrong. But yes, to elect to toggle your claim, you have to vote to accept the plan. And so if I believe that the borrower group's been working with a bunch of different people to try to find refinancing sources. And there are a couple folks that may be interested. If you want to receive more liquid cryptocurrency under the plan, you have to vote yes and check the box on your ballot to toggle. And as we said before, one of the solutions or the resolutions at the mediation was that borrowers will receive first priority for that toggle.
Yep, I just wanted to have it on the record, I guess, that you guys say it, because no one seems to believe me about it. But all right, thanks, guys.
Thanks, Tony. Steve Slade, are you there? How about Lazo? Yep.
I have a question regarding a corporate account. I'm a U.S. citizen, corporate account, and the corporate account is a self-directed IRA with a particular custodian that I set it up with, and then moved the crypto onto the platform. And in order to get it back, I have a separate account at another exchange, and I guess all I have to do is use the app, because it's a corporate account, and move it to that other exchange. Is that right?
I guess I'm not following. So you have an account that's set up through an IRA, and now it's on there's an account on another exchange with that same IRA,
yeah,
and you want to...
It's a self-directed LLC IRA. So it's a corporate account because it's an LLC. And so what I was asking is I saw the table that instead of going to PayPal, I would be able to move it using the app because it's a corporate account, to another corporate account at another exchange.
So you're right on that. PayPal is not going to be able to distribute to corporate accounts. And we are currently, the current plan is hopefully the person that steps in to do the international distributions can also step in to do corporate accounts. If that's not true, then the debtors will have to find some other solution for corporate accounts.
Okay.
I'm not sure about the specifics of the IRA or the transferring to another exchange.
Yeah.
And I would think that the best place to ask that question, again, is likely to the debtors through the Kirkland email address, who might be able to run it down in more specifics.
Yeah, it's a self-directed IRA, so I set it up legally to where I can put it into various different investments, and it doesn't require me to go through a particular external IRA. The custodian is a separate entity that allows you to then put money into a bank, and then you can then move from the bank into various assets, be it real estate or crypto or gold or whatever. It's just that I can't take it personally. I have to go into another corporate account in a distribution, and that's why it wouldn't work going into a personal distribution into PayPal. And then I guess the other question I have, I think you've answered that. I think the other question I have is, you said that there were going to be some amount of crypto that was going to be held back to cover litigation that, where people are opting out and all. How long do you think that will take to resolve, and will the avenue to move the crypto when it's given back to the creditors to, will they still be able to move it? I guess this international group that you're setting up would still stay active to allow you to then move it.
Right. So how the plan works, right, is if you have an allowed claim on the effective date, you'll receive your distribution because your claim is set. If you've got a disputed claim, the debtors will have to resolve the dispute and determine the amount of that claim before they're able to make a distribution to you. And we'll have to make sure that they hold back a sufficient number of assets so that if the claims are resolved, say there's a claim worth $100 and debtors believe it's worth $100 and you believe it's worth $500. If you're right, it's worth $500. They have to have enough cryptocurrency held back to be able to satisfy that claim. So how those claims get resolved takes a long time, right? That's one of the reasons we propose the ADR procedures, is to try to work through them in an efficient manner, but there could be a significant amount of them. And so one of the thoughts, as I mentioned, about having distribution agents instead of the company do the distribution, is that they will be able to distribute crypto over a longer period of time than if we use the company, so that those reserves, when they're released, can be distributed to the creditors through those distributions. Now, one of the other things that I think is worth mentioning is, as everybody knows, whenever you distribute crypto, you have to pay gas fees for it. So we're very focused on making that initial distribution as large as possible so that we can reduce the amount of gas fees that creditors will have to pay on getting their cryptocurrency back.
Yes, that makes sense. Thank you for your time.
Of course.
And
so I'll grab
Aaron.
Yeah.
Aaron, one point we didn't really touch on with PayPal that I want to make for the folks that are listening in is, there's no help desk if you make a mistake on a cryptocurrency distribution. And part of the reasoning with PayPal is to have a well-capitalized counterparty making these distributions versus a bankrupt company, just in case something went wrong. Because after all of this, that would just be a catastrophic outcome.
Right. So I guess we'll take one more question. I'll grab Max Goldberg if you're there before signing off for the day. You there, Max? All right. I guess seeing Max is not there, I'll pull up Tecmo if you're there.
And did Joe come back?
Tecmo, are you there?
Hey, yeah, you gotta, whenever you add somebody to the stage, there's a delay. So if you immediately say, "Hey, are you there?" then that's why all these people aren't hearing it. Just a heads up.
Got it. Thanks for the tip.
Twitter is fun.
X now, right?
I'm still gonna call it Twitter. But anyway,
I always wonder, are they still called tweets or what are they called?
I don't even know. How do you pronounce the new one? I don't know. Quick question. Two quick questions. One, if we no longer have access to the email, because apparently I didn't know this, but Tutanota, if anybody uses that, if you have 6 months of inactivity, it deletes your email. Will the code be physically mailed as well?
I don't believe it will be physically mailed, but I think the way that you should address that is to email the Stretto link.
Yeah, I did.
And I'm sure they'll ask for some verification and have to figure it out somehow. But I would reach out to Stretto via email to resolve that issue.
Okay. And I mean, just being pragmatic, like if the chance of a cram-down is possible, does it really matter? Like, should I even go through the trouble of getting my wife's, account, email situation to have her vote? Like, assuming this passes or it gets crammed down anyway, her not voting won't hurt her, right?
Not voting does not hurt you, but everybody should vote, right? This is like the civic process in the United States. If you don't vote, you don't have your voice heard.
Sure.
And we would encourage every single creditor to vote here, because that's the way that we can see the amount of support for the plan. And at the end of the day, bankruptcy is a democratic process, and I would encourage every single creditor to vote.
Okay. And then sorry, go ahead, Scott.
Hey, this is Ken. I mean, I just want to say, I mean, don't leave it as an assumption, right? If you have an outcome, the only way you're going to, do your part is vote. I wouldn't advise just sort of hoping that, that it generally passes, sort of no different than any other election.
Okay. Yeah, and speaking of the Democratic side of things, like I ran a poll recently, and the overwhelming majority that I've seen over and over in my time over the past year of people just want what's left of their crypto back. These were funds that were not investments; they were, essentially emergency funds or money for retirement or things like that. They weren't like, oh, let's invest in this startup type funds. So the overwhelming majority of people just want a crypto distribution that isn't a tax headache for what's left. So with that in mind, I'm just curious, like what, I know you guys worked hard for the past year to, devise this plan, get it passed, all those things. Why was that not a consideration that most people don't want funds in a mining company? They want just what's left of their crypto back. Like, why was that not a main consideration for the UCC?
So I'll say that was one of the most important considerations for us. We didn't get to pick the amount of assets or the type of assets that Celsius left us with. And we were presented with a number of different plans that presented a dramatically less amount of liquid crypto distribution. And I can tell you that Scott, myself, and Ken, we all fought like hell to get as much crypto back as possible, while at the same time trying to maximize the value of the assets that we did have so that people can get a return over time that we believe will exceed if that crypto was otherwise distributed out. So we were laser focused on trying to get as much cryptocurrency back to folks as possible. And I know that you can look at this plan and say it's not as great as what I would have wanted. Did we get every single thing that we want in it? No. Did we have differences of opinion within ourselves, within our group about what we wanted? Yes. But by working together, working with the debtors and working with Fahrenheit, we think we have the best way to get people back the best recovery as possible now. So that was, I just want to stress that, like you, we heard that and we responded.
Okay.
And I just want to say too, we haven't been holding this up trying to put together a reorganization as that's not the holdup. We had the preferred equity issue to deal with, the custody issues. We had, between borrow and earn issues. So This is the way that if you look at the numbers, we put the most value back in people's hands the fastest. And if you don't want the equity, you can sell that equity and you can buy crypto with it. This was the lemonade from the lemons we were left.
Okay. Yeah, I mean, I disagree, but I appreciate your guys' efforts. I think a liquidation and just maximizing the amount of crypto people got back. No, I mean, most people don't want a reorg. As simple as that. They don't want a NewCo. That's the fact. And so the fact that all this effort was put into a NewCo, it's your guys' opinion that maximizes the recovery and time. I disagree, but I still appreciate your guys' efforts.
Yeah, look, everyone's entitled to their opinion, and I appreciate you expressing yours. I think if we liquidate that mining business, we get back pennies on the dollar. So, that's the best part of this process, and I'm very happy that we're able to have an open and civil discussion about it.
Yeah, I appreciate it, guys.
All right, thanks, Tecmo. So with that, I just want to say thanks everyone for joining. Thank you to our committee members. Tom and Scott have been up there. We really appreciate everyone's support. We believe that this plan's the best way to get out of bankruptcy. We encourage you all to vote for the plan. We're going to be doing a couple more of these, and we've got more court hearings, and we are focused on getting out of bankruptcy. That's priority number one for us. So appreciate everyone's time. Scott, I don't know if you have any closing remarks before we sign off.
No, I just wanted to say thank you, everybody, for attending, for your questions, and just know that we are working really hard to get this moving. We're excited about having the disclosure statement approved and look forward to the vote and getting out of bankruptcy. We are laser focused.
Great. Thanks, everyone. Have a great day.
Thanks, everybody.